everyone. So hope you are all doing well. And today we'll be studying about the Sales of Goods Act. So contents for today's video would be the caveat emptor and the exceptions of the caveat emptor. So let's begin today's video. So doctrine of caveat emptor. Caveat emptor is a Latin phrase which means buyers beware. Buyers beware means buyers be careful. Now, this caveat emptor doctrine means a theory or a principle. So, doctrine of caveat emptor is a Latin phrase which means buyers beware or buyers be careful. This doctrine is based on the concept that the buyer must ordinarily buy goods after satisfying himself of their quality and their fitness of the product, and the seller is under no obligation to disclose the defects, if any, of the goods. If the buyer makes a bad choice, he cannot blame the seller for the same, and he cannot get the damages from the seller. This means that the doctrine of caveat emptor want to state that the buyer should be careful. He has a responsibility to check the quality of the goods he is buying, and he should verify or he should confirm himself first that whether the goods will meet the purpose for which he want to purchase those goods. And the buyer has the responsibility to discover the defects, if any, in those goods, and the seller is not bound to tell him about the defects of the goods. So afterwards, after he is satisfied with respect to the quality fitness of the goods, then only the buyer should take the decision to buy the product. And if the buyer makes a bad choice or a wrong choice, then seller will not be compensating the buyer for the same. Basically, caveat emptor is made to protect the seller. This doctrine, therefore, do not apply where the buyer has disclosed the purpose for which the goods are required and relied upon the seller's skills or judgment. This means that when the purpose for which the buyer will be taking those goods, purpose is disclosed to the seller, or the buyer is relying on the seller's skills and knowledge, then the seller should give the goods which is meeting the purpose. And here, if the goods are later on found that they are not meeting the purpose or they are of not good quality, then the seller shall be held liable. So the last point deals with the exception to the rule of caveat emptor. The buyer and the seller have equal access to information about the goods or item that is bought and sold, and the buyer has a right, or he is able to make the personal inspection of the goods before he will buy those goods. Now let's understand caveat emptor with the help of the case studies and illustrations. Here, Ram bought 10 cows from the cattle broker. Out of 10, 2 cows were having some defects, means those cows were infected from some disease. However, Ram did not know about this because he didn't check all the cows, means he didn't do the medical examination of those cows before buying those cows from the cattle broker. What happened after the purchase? He paid for all the 10 cows. After the purchase, within 3 days of purchase, the 2 infected cows died at Ram's place. Now Ram faced the loss. So the question here is that will the cattle broker be compensating Ram for the 2 cows, or he'll get the refund of the price? Answer is that there was no tacit condition that the cows would be of a great health at the time when the sale took place. So the seller has not given any guarantee that the cows are of good health. it, and Ram cannot hold the cattle broker liable because he didn't disclose the defect, right, in the goods. But the cattle broker cannot be held liable for selling the infected cows to the Ram. It was Ram's basic duty to check the health of the cows, and it was he cannot expect the cattle broker, the seller, to disclose all the defects in the goods. So here, the cattle broker was, I would say, protected under the caveat emptor, and Ram will not be getting any compensation for the bad choice which he has made. In the case of Jones versus Paget, the buyer bought a cloth for making uniforms. However, the seller was not aware of the purpose of buying the cloth. Later, the buyer found that the cloth is not fit for making uniforms. It was, however, fit for other normal purposes. The seller was not found guilty as the principle of caveat emptor applies in this case. This means that the principle of caveat emptor apply in this case, and the seller will not be compensating the buyer for making the wrong choice, because the purpose for which the buyer wanted to use the cloth was not disclosed to the seller. Principle of caveat emptor deals with the quality of the goods. The seller is not bound to disclose the defects in the goods which he is selling. Because if he will be disclosing all the defects in the goods, no one will take those goods. Who the buyer in this world will be taking the goods which are defective in nature, right? So it's seller's bread and butter to sell. So obviously he earns his bread and butter by selling those goods. So why he will be telling the buyer all about all the defects? It's buyer's duty to find out the defects, if any, in the goods before buying those goods. At the time of buying goods, the buyer must make the reasonable examination of the goods as to satisfy himself regarding the suitability of the goods for the purpose he buys, and as to discover the defects. So buyer's duty is to find out the defects in the goods, check the quality of the goods, check whether the goods will meet the purpose or it is fit for the purpose for which he is buying. And if the goods turned out to be defective or do not suit the purpose later on, then the buyer cannot hold the seller liable for the same. So seller will not be compensating the buyer. Now, these are the 8 cases which are listed under the exception to the caveat emptor. So the caveat emptor protects the seller, and here, if these under these 8 cases, the seller will be still be liable to compensate the buyer. So these are the exceptions to the rule of caveat emptor. So the first one is sale by sample. In a contract of sale by sample implies an undertaking. So whenever a sample is shown and thereafter the bulk order is placed, there is an implied undertaking from the seller that the goods which will be supplied in bulk will be similar to the sample given to the buyer. And if the goods do not correspond to the sample, it amounts to the breach of contract because the condition as to sample got breached by the seller, and the buyer will be entitled to reject the goods. In Wallace versus Brett, a contract of sale was entered between both the parties, and according to which the English sainfoin seeds will be supplied. When the sample of the sainfoin seeds was shown, the seeds were basically small in size, but the bulk in which the goods were sold to the buyer, it was joint sainfoin seeds. Basically, the size of the sainfoin seeds was not matching with the sample, and therefore the court decided that the buyer can repudiate the contract of sale because the sample and the bulk is not matching or not corresponding here, and the condition as to sample is got breached by the seller. Usage of trade. where the usage of trade annexes an implied condition as to or warranty as to the quality or fitness for a particular purpose, and the seller deviates from that, the rule of caveat emptor shall not be applicable, which means that the goods for which the purpose for which the goods are bought, and if the goods are not able to perform or perform that function for which it is being bought, then the goods shall not be tradable, and the caveat emptor also will not be applicable in that case. Here, in the case of refrigerator, a dealer was selling a refrigerator to the buyer. Refrigerator could perform all the functions except making ice. And obviously, we know that one of the important function of the refrigerator is to make ice. And this was not, the machine was not able to do so. So this amounts to the breach of warranty as to usage of trade, and the doctrine of caveat emptor shall not be applicable. The buyer can reject those goods. Consent by fraud, where the seller makes a false statement intentionally to the buyer and the buyer relies on it, or where the seller knowingly conceals the defects in the goods, the doctrine of caveat emptor does not apply, as the buyer did not give his consent freely. He was kept in dark regarding the contract that he entered into with the seller. This means that whenever a consent of the buyer is not free and it's being influenced by fraud, then the caveat emptor principle will not be applicable, and the seller shall be held liable for selling those goods which are not obviously having some defects and where the buyer's consent is not free. Here, in the case of Smith versus Green, what happened that both the parties, Smith and Green, so we have taken it as A and B for our convenience. So A will be selling an animal to B from A's farm. So B selected an animal and requested A to confirm that there is no sickness in that animal. So here the seller had to confirm whether their animal was suffering with some sickness or not. Actually, the animal had been suffering from some sickness, but A, the seller, concealed that fact. So he didn't say anything about it. And what happened? The sale took place. And thereafter, at the buyer's place, the animal died. So it was obviously fraud when when a buyer is asking for the seller to give him a confirmation with respect to the quality of the goods he is selling. Then obviously, if some defects are there, the seller was duty was to inform the buyer, but he didn't do it. So here, the contract is influenced by fraud, and consent received by fraud means the contract can be void, can become void. So here the court decided that the buyer can get the amount of refund of price from the seller and the contract can be repudiated, means it will be cancelled. Merchantable quality, where the goods are bought by description from the seller who deals in those goods of that description, there is an implied condition that the goods shall be of merchantable quality. This means that the goods should be commercially sellable. And if the goods are not meeting the commercially, means they are not of a merchantable quality or they are not commercially sellable, they are defective in nature, unsuitable, then the caveat emptor shall not apply in this case and the buyer can reject those goods or cancel the contract. But suppose the goods are personally inspected by the buyer and buyer confirmed that the goods are commercially sellable, he will be able to sell those goods in the market and he will be able to get the full value of the same. And after the reasonable examination and personal inspection, the buyer is taking those goods from the seller, then the seller cannot be held liable over here. Later on, if the buyer is unable to sell those goods in the market, then the buyer cannot blame the seller for giving the goods which are of unmerchantable quality, because the buyer himself confirmed to the seller that he will be able to sell those goods. So there the caveat emptor applies. Here, the Buyer bought some undergarments which contained some chemical. The cloth was containing some chemical and which could cause the skin disease. So obviously, no one will buy the goods which will be harmful for the skin. So it was held that the goods are of not merchantable quality, and the buyer could reject the goods and claim damages. Sale by sample as well as description. Where the goods are bought by the buyer from the seller, considering the sample as well as description, the rule of caveat emptor does not apply if the goods supplied by the seller do not correspond with both the sample as well as description. The buyer can reject the goods. Means here, if both the sample and the description, both the conditions need to be met as per the contract of sale, so the goods should also meet the description as well as should also correspond with the sample. Then only if both the conditions are meeting, the goods will be accepted by the buyer and the contract will be executed. Otherwise, the buyer can repudiate the contract. In this example, there was agreement to sell between A and B, according to which A has to sell a harvester to B. While selling the harvester, the machine, A gave a lot of description about the machine. On delivery, B found that the machine's description and the delivered product, is not matching. So B sues for repudiation of the contract. Court decided that the delivered goods are not in accordance with the given description. The caveat emptor shall not be applicable in this case, and hence the buyer can repudiate the contract and reject the goods. Fitness for purpose. Here, where the conditions are like where the purpose for which the buyer is buying those goods is disclosed to the seller. Buyer relies on the knowledge, skill, and the judgment of the seller, and the selling of those goods is a normal business activity of the seller. If these conditions are meeting, then the seller shall be held liable to sell the goods which are not fit for the purpose. So in the here the rule of caveat emptor will not apply, and the buyer can repudiate the contract and can reject the goods. In the case of priest versus last, a buyer bought a hot water bottle from the chemist, and the chemist had given the bottle, the quality was not fine and it was not fit for the purpose, because when the water was filled in and it got burst and injured the wife of the buyer. Here, the purpose for which the buyer was taking the hot water bottle was obviously disclosed, because the hot water bottle will be used for medical use. So, purpose was known to the seller. The buyer relied on the chemist, that is, the knowledge of the chemist, because chemist was knowledgeable enough, because he was selling those bottles or these goods as a normal business activity. So obviously this the chemist will be knowledgeable or skillful enough to give him the better quality bottle which fit the purpose for which he is buying. So here the chemist was held liable to compensate liable, and he has to compensate the buyer for selling the not better quality bottle to the buyer. Sale under patent or trade name. Where the buyer buys goods for a particular patented brand, it is expected that the goods are of certain quality and standard. But there is no implied condition as to its fitness for any particular purpose. When the buyer buys an article by specifying its patent or trade name, there is an implied condition of the fitness of the goods for any particular purpose. Now let's understand this. So whenever a particular patented brand or particular branded goods we talk about, suppose we talk about brand Nike. Nike is for bags, for shoes, everything. So let's take a shoes example. That a Nike shoes are being there will be purchased by the buyer. So obviously the company will be meeting certain quality and the certain standard for the shoes which it is manufacturing, because the company has its own brand name. But the buyer's purpose for which he wants to use those goods may be opposite, right? And whatever the goods whatever the purpose for which he want to buy those goods, and the standard and the quality which the company has may not match many times. So buyer need to be careful about it, and buyer need to find out whether those goods will be fit for his purpose or not. And thereafter, after he is satisfied that this company's product is perfect for him and this product will meet the purpose for which he want to buy it, then only he may proceed to make a decision to buy and proceed to enter into a contract of sale with the brand or with the company with respect to those goods. When the buyer specifically mentions the brand name or the trade name, means when you go for a shopping and you say that I want a mango, or I want a, I would say, Levi's or any other brand. So obviously the seller's duty is that he should specifically give you that brand. Because if the brand is mentioned, product is mentioned that I want a Levi's one or Levi's jeans or whatever, so the jeans which will be given or supplied by the seller should be Levi's. Otherwise the buyer will not be taking those goods. And when the buyer is choosing Levi's, after being satisfied that the Levi's will be perfectly matching the purpose or meeting the purpose for which he want to use the goods, then the product Levi's should be of such quality and standard that it meets the buyer's purpose and satisfies the buyer's demand. Here, in the case of Bale versus Taylor, a car was being described, or the brand is Herald Convertible 1961 model. The buyer purchased the car, and later it was discovered that the rear part of the car was of a 1961 model, as mentioned by the buyer, that he wants a 1961 model, but the front half of the car was some earlier model. The buyer could reject the car and can recover the amount paid, because the goods the which was mentioned as a brand which was mentioned was the Herald Convertible 1961 model, and the car was not meeting that. The first rear part was meeting it, but the front car was not meeting the brand which was being specified. So obviously this condition is getting breached here. Buyer has a right to reject the car, and he can get the full amount which he has paid to the seller. Sale by description. Where the goods are sold by description, there is an implied condition that the goods shall correspond with the description. This means that the description of the goods and the product should match. When the buyer is suppose buyer has said that he wants a particular, suppose he wants a green packet, I would say, of lays chips. We are talking about the chips. So buyer specified or described that he want that flavor, the green one. I'm telling about the color of the thing. I'm not talking about the flavor. So it's a color, it's cream and garlic is there, the green one. So we are talking about that. So a green packet was demanded. So if the seller is giving him not that one and he is giving him the red one, that is the tomato flavor. So obviously buyer will not be accepting those goods because the description is not matching. Buyer described the product that he wants the green one. So obviously the green packet of Lays of that is the garlic and lemon, garlic and butter and that cheese flavor should be there. So he will not be satisfied with the tomato flavor. So the goods which is given should match with the description. Otherwise, the buyer has a right to cancel the contract and reject those goods. And here the caveat emptor shall not be applicable. This comes to an end of today's video. And we have covered today the caveat emptor and the exceptions of the caveat emptor. So, hope everyone has understood everything with respect to this topic. Thank you all for your patient listening.